supplementary cause list, item number 1.
Please vote. This is an application under 439 for grant of bail to the son of the petitioner before your lordships. Lordships, the accused is one of the co-accused in connection with a case which is pending before the Sessions Court at Joai, West Jayantha District. Lordship, the charge sheet has already been filed and 2 witnesses have already been examined, being the complainant and the alleged victim. The charges are under section 307, Lordship. Now, the accused person here, my lord, has been in custody since 4th of June last year. So as such, it has been 4th July. So it's been 1 year, Lordship. And another 5 or 6 witnesses are yet to be examined. In fact, today also the matter was fixed before the learned trial court. But however, the learned trial court is on leave. So today also examination. Now today it is fixed for cross-examination of PW2 by the counsel of the co-accused. From the last 3 dates, that has been the position, Lordship. Now this is the 4th bail application, Lordship, in connection with the prayer for grant of bail to the accused person. The first application for grant of bail was filed before the learned trial court in the month of October 2023 after filing of the charge sheet. However, the learned trial court deemed it fit not to enlarge the accused person at bail at that stage, saying that there may be an apprehension of influencing the complainant and the victim. Though it was rejected, Lordship. Thereafter, after the examination of the complainant, another bail application was moved, and that also came to be rejected on the ground that, Lordship, there is an apprehension that the accused person may influence the alleged victim. Thereafter, Lordship, another bail application was filed, and that also came to be rejected, despite the examination of PW2, who is the alleged victim, being complete as far as the instant accused person is concerned. The matter has been now fixed for further cross-examination of PW2 by the co-accused. And Lordship, the bail has been rejected at this stage after the examination of the alleged victim on the ground that the witnesses may be influenced. So my humble submission, Lordship, is that on the presumption of his guilt, whether he has committed an offence punishable under 307 or any other section, the question, Lordship, will be tested in trial. Now, Lordship, two witnesses who are the complainant as well as the alleged victim in a 307 matter, they have already been examined. Accused person is in jail for over a year, Lordship, and on the deal, and the co-accused is already on bail. And because of certain reasons, because of the presiding officer being on leave, some difficulties of the co-accused person, sometimes our difficulty, accused person is lying in jail for over a year, Lordship. So my humble submission is, my lord, that at the time of the filing of the charge sheet, he has duly cooperated, and thereafter also, in any event, he has been facing the trial. No question of him absconding, because he's still UTP, Lordship. Time and again he has faced the trial. They know no such adjournments also have been taken by the co-accused to delay the trial. He has already examined from his part, Lordship. So my humble submission is, Lordship, that considering the facts and circumstances and the prolonged custody of the accused person, to punish him by keeping him in jail, Lordship, amounts to a punishment. So that may not be warranted, Lordship. So in such regard, I humbly pray that the accused person may be enlarged on bail on certain strict terms and conditions, and both the petitioner as well as the accused person will comply, Lordship.
How many accused are there in this
Lordship,
case?
there are 2 accused, if I may take your Lordship.
They are both in custody.
No, the second accused is already released on bail, Lordship. However, that was default bail. The other co-accused was released on default bail. If Lordship is pleased to see the FIR at page 28. Page 28, Lordship, is the FIR dated 9th of March. That, sir, on so and so, at around 7:30 p.m., 2 persons, namely Damut Bang. So Damut Bang is the accused person here, Lordship, and Parmon Sari, co-accused, both residents of so and so village, intentionally stabbed my brother, namely so and so, on his belly at so and so place with serious injury, where he was taken to Joai KJP Hospital for treatment where he was totally unconscious. It may be noted that these culprits have time and again threatened my brother with dire consequence.
Yes.
Please, Your Lordship. Your Lordship, in the FIR, Your Lordship, both the accused persons are named accused persons. There are many eyewitnesses who have seen the occurrence, Your Lordship. They have been, the accused who is still in the jail, Your Lordship, he has deliberately, in the presence of many eyewitnesses in a tea shop, Your Lordship, attacked the victim, the PW2, Your Lordship, and he was in the ICU for over a month. He was several times he stabbed the victim, and the victim was in fact, Your Lordship, this person had come before Your Lordship earlier last year for anticipatory bail. If Your Lordship recalls, and Your Lordship was pleased to reject the anticipatory bail also, Your Lordship. Now, Your Lordship, this is the fourth time they have come. 3 times they have already moved before the district and sessions judge, and this is the 4th time they have come. And the district and sessions judge, Your Lordship, after going through the evidence of the PW2, the first PW1 was the complainant, the brother of PW2. PW2 is the victim, Your Lordship, who has narrated the entire incident, and on seeing that the district and sessions judge was convinced that there is a prima facie case, and that this accused person, being a dangerous man, and that he was not cooperating with the IO also, Your Lordship, initially. It was only much later he surrendered before the IO, that he should not be allowed to release on bail, considering the gravity of the offence committed, and also because of his character. There are some more vital witnesses, especially the eyewitnesses, who are yet to be examined, Your Lordship, and it is strongly apprehended that this person will influence the said witnesses, Your Lordship, which is why the district and sessions judge has been pleased to reject the bail application, Your Lordship. If Your Lordship will see at page 58, Your Lordship, the district and sessions judge's observation that on close scrutiny of the evidence of PW2, who is the victim in the instant case, this court finds that there is a prima facie evidence against the accused person, Damut Pang, of his involvement in the instant case. Further, keeping in mind the nature and the gravity of the offence, the release of the accused on bail would not be proper at this stage. Vital witnesses are yet to be examined. So, finding the bail application devoid of merit, Your Lordship, he has been pleased to reject it. So my prayer is that, Your Lordship, since the vital witnesses are yet to be examined, the eyewitnesses who were present there at the time of occurrence, Your Lordship, there is every possibility that there will be they might be threatened, they might be influenced some way, which is why, Your Lordship, in the interest of justice, this bail application may be rejected, Your Lordship. Your Lordship was pleased to reject the anticipatory bail on 4/5/2023 also. On this prima facie affairs,
Under the then circumstances.
Correct, Your Lordship, that there is a serious offence and subject to further evidence, perhaps a case under 307 may be made out. However, from the conduct of the petitioners, it appears that they have failed to cooperate with the investigation. This is what Your Lordship had observed while rejecting the anticipatory bail. And as such, the liberty given by the court was flaunted because interim bail had been allowed. Accordingly, this court finds no reason to continue with interim protection given to the petitioner. In view thereof, the connected applications are dismissed as devoid of merit. And under the then circumstances, Your Lordship, but Your Lordship was also pleased that there is evidence that crime has been committed.
You see, prima facie evidence could be there. Otherwise, charges would not have been filed.
Would not have been there.
But we know very well. You see, it is.
But there is a.
It's needless to say that it's just a matter of trial, as to whether there are sufficient evidence to come to the conclusion that the accused is
Guilty.
at fault or involved or.
Let the eyewitnesses, the main eyewitness, be examined.
How many witnesses are there?
There are 9 witnesses in total. We are still stuck with PW2 for the last 3 months. Now, my humble submission is
let the eyewitnesses, especially the first person who was a shop owner, who see the entire incident and who was trying to stop the fight from going on, be examined, Your Lordship.
one more aspect
Before your
is,
lordship
Lordship,
deems it fit to grant bail.
Two persons have been named in the FIR to have assaulted the alleged victim. One is already on bail.
He was on default bail.
Default bail, but the issue is, for all practical purposes, he is at home. The question
He
of
was not the one who committed he stabbed the victim, your
The
lordship.
question of influencing the eyewitness at this stage, after 1 year, lordship, from the date of my arrest.
He is an influential and a dangerous person, as per the evidence of the witnesses.
What are his antecedents? Any criminal records?
No criminal antecedents. In fact, the alleged victim has some criminal antecedents, but that is a different matter. No criminal antecedents, lordship. He is a family man having minor children, living with his wife in the village. And in our humble submission, the incident was a result of squabble, but that is also a question of trial. But at this stage, lordship, as I stated, lordship, two witnesses have been examined by the court, by the accused, without taking any time. Now, for some reason or the other, the trial is also being delayed, lordship. For example, today also the matter was fixed. The learned presiding officer is on leave. And
I'll allow you to go on bail.
With very stringent terms and conditions.
Condition, of course. You know very well. See, purpose of bail is only to ensure
that he does not abscond or he tampers with the evidence.
And if the main witnesses, or rather the complainant has been examined.
Victim also has been.
But the eyewitness has not.
Yes, of course. Eyewitness will just corroborate the incident.
Hopefully, your lordship, if he is not influenced by the.
No. We'll avoid all contact with all the witnesses and the
Mr. SD and counsel for the petitioner, for the applicant, who has submitted that the applicant being
he's the father, lordship.
He's the father.
Father of the accused person.
The applicant is the father of Sri Damut Bang, who is one of the accused person, presently in custody in connection with July PS case number 31/3 of 2023. Now being registered as Sessions case number 14 of 2023 after charge sheet have been filed implicating the accused person in question. And there are two accused persons?
Yeah, two accused.
And another co-accused. It is the submission of the learned counsel that the accused person is in custody for about a year.
Since 4th July.
Since 4th July last year. 1 year.
For about a year or so. And in the meantime, the trial has proceeded with the evidence of two witnesses being recorded. The complainant and the victim are two different persons.
Yes,
two different persons.
Complainant is the brother and the brother of the victim.
Complainant and the victim being examined as PW 1 and 2 respectively and discharged.
PW2 is yet to be cross-examined.
PW2 yet to by the PW 1 and 2 being examined. No? The PW2 is yet to be cross-examined
By the co-accused.
You have already examined cross-examined?
Already cross-examined
The co-accused. The accused person in question have already cross-examined the said PW2. In view of the fact that there are about 9 witnesses. it is the submission of the learned counsel that the trial may take some time, for which the cause, or rather the rights of the accused person in question would be violated by prolonged incarceration in custody without being afforded proper opportunity to prepare his defense. On this ground, the learned counsel would submit that this court may be pleased to enlarge the accused person in question with any condition that may be imposed upon the accused person in question, to which he will abide by such conditions. What is the vocation of the accused person?
Lordship,
He's written as self-employed, so we are not quite sure.
Labourer, basically, Lordship.
Labourer?
Labourer. Small village
No,
labourer.
I don't think he's a labourer. I'm told he's a businessman. He was quite moneyed man. That is what, on going through the records, I have gone through that. He's not a labourer.
Petty, like the village, this small business selling the things, farm, not very professionally employed.
And Your Lordship, I just wanted to draw your attention. In this bail application, Your Lordship, the accused person, and they have stated that it is a case of self-defense. And this is the first time they have taken this plea. All along. So, of course, he has not mentioned that whilst making the submission. But that should not be taken into consideration.
That will be a matter of trial. Yes. In a bail application, those factors are not taken into account.
Yes.
In fact, time and again, the court, either releasing or not granting bail, would also caution the trial court not to take into account
whatever statement has been written in the bail application.
Because that, as far as trial is concerned, it's a different, kettle of tea altogether. Ms. Yangi, learned AAG, appearing for the state respondent, has, however, vehemently opposed the prayer made in this application, and has submitted that the courts would show that there is concrete evidence to implicate the accused person in question in the alleged offence, as far as the offence is concerned, in as much as there are eyewitnesses who have witnessed the fact that the accused person in question has stabbed the victim
several times.
Has stabbed the victim several times, leading to severe injuries inflicted upon the said victim, who has to be admitted in the hospital and was in the ICU for about a month or so. The main concern of the learned AG is that the main witnesses, that is the eyewitness, is yet to be examined, and if enlarged on bail, the accused person in question may threaten or intimidate such witness, which would then jeopardize the case of the prosecution. It is under such circumstances that the learned AG would reiterate her opposition to the grant of bail to the accused person in question at this juncture. Anything else? This court has carefully considered the submission made by the parties and is aware of the fact that the accused person in question is in custody for about a year or so, since he was arrested on
4th July
4th July
2023.
There is no criminal antecedent as far as the accused person in question is concerned, though his involvement in the case in question is yet to be proved. Which is a matter of trial and evidence to be appreciated, evidence to be recorded and appreciated by the trial court. For which the outcome would determine the fate of the accused person in question. At this point of time, this court is of the considered opinion that since the formalities of investigation is completed and this case is at the stage of recording of evidence, it goes without saying that the accused person is no longer required for custodial questioning. In fact, it is a well-settled principle of bail jurisprudence that bail is the rule and jail is the exception. Of course, under the particular facts and circumstances of the case in question, of a particular case, of a case, at this stage, it would be the concern of the court that if enlarged on bail, the accused person in question shall not abscond and that he shall cooperate with the trial. And also that he shall not intimidate the witnesses. If these conditions are adhered to by the accused person in question, this court finds that there is no reason for the accused person in question to be detained, to be further detained in custody. Accordingly, this application is hereby allowed, and the accused person in question, that is Shri Damut Bang, is hereby directed to be released on bail on the following condition: that he shall not abscond or intimidate the witness, that he shall cooperate with the trial as and when called upon to do so, that he shall bind himself on a personal bond of 20,000 with one surety of like amount, that he shall not leave the jurisdiction of the court without prior permission from the trial court. Anything else? Needless to say, violation of any of the conditions set forth here and above would allow the prosecution to take steps for cancellation of the bail granted. With the above, this petition is hereby disposed of.
Item number 2.
My lord. But this is a contempt application, my lord, for willful violation of the judgment and order dated 31st/10/2023 passed by this honorable court, my lord. My lord, may kindly come to the judgment, my lord. Is at page 15.
But have you taken step for issue of notice?
My lord, notice has to be issued by this honorable court.
So let that aspect be
My lord.
first dealt with.
My lord.
Once the parties appears, then we'll see.
My lord. Let notice be issued, my lord. In the first place.
Ms. Archival Data and counsel for the contempt petitioner. Who has submitted that this application has been filed. To bring to the notice of this court the willful and deliberate violation of the judgment and order dated 31/10/2023 passed by this court in WPC number 44 of 2015. Such act being perpetrated by the respondent herein. Such violation being attributable to the action of the respondent herein. However, the learned counsel would submit that at this juncture, notice may be allowed to be issued upon this said respondent. Accordingly, let notice be issued on the respondent, the same being returnable within 2 weeks.
We'll take to register post, my lord.
How you issue notices according to procedure?
My
To registered post or whatever is acceptable, whatever is in the rules. This is the matter thereafter. After 2 weeks.
lord.
Item number 4.
My lord, service is not yet complete on respondent number 2, 3 and 4, my lord.
2, 3 and
2, 3 and 4.
so we'll wait.
Let it come up after 2 weeks, my lord.
Ms. R. That counsel for the petitioner has submitted that the service report on the notice issued upon the respondent number 2, 3 and 4 respectively has not yet been received. It is prayed that some more time may be allowed for a report of delivery of such notice to be filed. Accordingly,
The interim bail may kindly be extended.
on prayer may the same is allowed. In the meantime, as prayed for, the interim relief granted to the petitioner is to continue until the next date fix.
Repeal.
Only is the matter up to 2 weeks. It is the matter up to 2 weeks.
Malik, Selamat datang. Baik, Panjang.